presiding. All ye have business with this court, draw nigh, and ye shall be heard. God bless the United States, this state, and this court. You may be seated.
All right, good morning, everyone. Let me first address the media that are gathered here with us today. This phase of the trial is the punishment phase, but it's also the defense's opportunity to present evidence. I am advised by counsel for the defense that there are some witnesses who are going to testify that will include testimony regarding certain sexual abuse that was alleged to have occurred. Because of the nature of that testimony, I'm going to instruct the media that those witnesses will not be shown on camera, nor will their names be given out and the counsel is going to advise me when those witnesses are necessarily going to be brought into court to testify, and then we'll take those steps. It has nothing to do with anything other than protecting the rights of the individuals who are called to testify. Based upon those facts, then, is there anything before we bring the jury in? That's fine. You go ahead. I had advised counsel of one issue that I wanted them to confer with their client about before we began. All right, Mr. Evans, at the conclusion of our hearings on Saturday, Mrs. Baker had testified and had given her victim impact statement. The court failed to question whether or not, or request you to advise us whether or not you wanted to ask her any questions on cross-examination. That was your right. Did you have any questions you wish to ask?
We had no questions that we wished to ask, and we've spoken with Mr. Wiggins, and he agrees that there was no questions he would have wanted to ask of that witness, and there was no issue with the court not asking that question.
All right, so that the record is clear then, Mr. Evans has conferred with the defendant. The defendant's waived any cross-examination of Mrs. Baker, who did appear as a sworn witness, and giving her victim impact statement so that we have that issue. In addition to that, I've been handed two questions by the juror that I will, regarding the victim impact statement, that I will, when they come in, I will address them on the record and give them my instructions about that. So then we are ready to bring the jury in. We'll need the 4 jurors to be brought in. Well, I'm going to bring the 12 in first now that we reorder. One of the things we've done in order to ensure that there's trying to prevent any of the jurors being shown on camera is we've reconfigured how they're going to be seating. They'll still be separated and kept separate for the alternates, but we're going to have them sitting further over so that they're not caught inadvertently on camera. Mr. Hopkins?
Could we rearrange the podium for the...
Yes. Ladies and gentlemen, I told you at the beginning we don't have assigned seats, but we're actually trying to reconfigure. So one of the principal efforts that we've made has been to protect your identity and your privacy in serving on this jury, and that includes the 4 alternates. When we had them sitting in the front, we were trying to avoid any possible inadvertent exposure to camera that might have resulted from when a witness is testifying. So to avoid that, we've moved their chairs, and we're going to have them sitting over here. They'll still be separated and apart from you, and you won't be able to talk to them or discuss this case with them. And likewise, you're not to discuss with any of among yourselves anything that's taken place up to this point. So please reserve your discussions for the jury room, and reserve it for the conclusion of the punishment phase and the final instructions and argument that you will receive. We're going to wait for those 4 alternates to come in, and then once they're here, we'll begin. And there are 2 questions I've been handed. I'm going to address those questions with you on the record. ladies and gentlemen, I appreciate the alternates and their patience and cooperation in doing what you've got to do in this case. Prior to the commencement of court this morning, I was handed 2 questions. Those questions are from the jury, and I will read those for the record. Procedural question. During the punishment phase of a trial, are there any parameters given to a person who will be giving a victim's impact statement? Anything that they can or cannot say in court? Are they limited to what they can say, how they say it, and to who? Second question is, if the victim impact statement was or is evidence, could the jury have a copy of it, a printed copy? Ladies and gentlemen, these proceedings are governed by a pretty strict set of rules, and I will tell you that you will be given instructions at the conclusion of the penalty phase in this case, and that will include instructions about the victim impact statement and how you're to consider it and what role it plays in your proceedings. And at this juncture, that's really all I can tell you. So the instructions will be how you are to consider, how you're to, what you're to do with the victim impact statement and so forth. But I can't go beyond that at this point. Everybody understand? All right. And with that having been done, I believe we are ready for the defendant's proof, and defense may call your first witness.
Your Honor, before we call our first witness, we had reserved an opening statement.
That's correct, I'm sorry. I did, if you recall, allow the defense to reserve their opening statement for the beginning of their proof, and so I will now allow the defense to make that opening statement.
The last time that I spoke with you, I told you that we would respect your verdict, and we do. We also previously told you that the trial would not be a meaningless exercise. By your verdict, you have determined that Stephen Wiggins will never again be free. Before I tell you what you're going to hear in this case, it's important that you understand how different this phase of the proceedings are from the last phase. In the last phase, you were the trier of fact. You determined what happened and whether Stephen Wiggins did the things he was accused of. This decision you're going to be making in this phase of the proceeding is a moral decision. You're going to be asked to make a personal, moral decision. Now, when we were in jury selection, we discussed with you that a death sentence only results if all 12 of you, in making this personal moral decision, decide that a death sentence is necessary. But if one or more of you decides for your own personal reasons, after listening to all of the evidence, considering everything you've heard, hearing the arguments and the jury instructions the court just told you you're going to hear, that a life sentence without the possibility of parole is sufficient to punish Stephen Wiggins and protect the community, then there won't be a death sentence. But each and every one of you decides for yourself. And because each and every one of you decides for yourself, and it's this personal moral decision, then the law never requires a death sentence. Now, this sentencing hearing is not simply going to be about the crime. It's going to be about Stephen Wiggins' life. If it were only about the crime, then his life story and these mitigating circumstances that you've heard so much about in jury selection, and that you all told the court that you would give meaningful consideration to, would be meaningless. It wouldn't be necessary. But it is necessary, and it's required. And you all repeatedly assured us in the court that at this phase of the trial, you could do just that. You will recall during jury selection, we discussed many times about you have to assume that you would get to this point and try to put yourself in that mindset of, when I'm in this position that you are today, I could now give meaningful consideration to this mitigation evidence. And the court's going to tell you, it's up to each of you to decide what is mitigating and how much weight to give to it. Some of you might give the weight of life to certain mitigating circumstances you're going to hear. For example, things like the terror and sexual assaults and physical abuse inflicted by Stephen's father on him and others, whether that warped his development and his moral compass, you may decide that that's a reason to punish him for something less than the death penalty. That is, give it the weight of life. Or the fact that Stephen has helped others in his life. How you will hear in this case that he actually saved the life of a coworker. That may be relevant to you, but it might not be relevant to another juror. And you could give that the weight of life. But you have to remember, this isn't a counting exercise. This isn't you just count up all of these mitigating circumstances. There's no magic number you have to reach. A single mitigating factor, a single piece of mitigating evidence could be the reason that you, in your individual moral judgment, decides to give that circumstance the weight of life. You have to decide whether that mitigating evidence is going to be sufficient or appropriate to grant mercy. Not because Stephen Wiggins deserves it, but whether what you hear about Stephen's life, what you hear about his experiences, you find in your heart that mercy should be extended to him. Your decision this past Thursday, well, by that, you've decided that Mr. Wiggins will never, ever set foot outside of a prison again. That's already decided. The next few days, though, what you're going to be deciding is something even more serious. Our society gives two punishments that are considered the worst: the death sentence and life without the possibility of parole. But it's important, as we discussed during jury selection, that you understand this. Nothing we are going to present to you in the next few days is meant to excuse or justify what happened here. And nothing changes the fact of what you will hear, that Mr. Wiggins will never get out of prison. We're going to provide you evidence that we think is important for you to make this decision of life or death. These mitigating circumstances that you've heard about during jury selection. Again, we're not presenting it as a justification, and we discussed this at length during jury selection. We are past that point. But it's evidence that we believe are compelling reasons that the life without the possibility of parole is more appropriate than death. None of it's an excuse. None of it is a justification as to how Stephen Wiggins may have acted as an adult. That's not why we're presenting this evidence. But the question is going to be whether Stephen gets executed by the state of Tennessee. And it's our job, and it's our responsibility, and it's even a privilege to give you these reasons. Now, you might say, why is it a privilege? It's because, as you can imagine, we've spent a lot of time gathering information about Stephen Wiggins' life, about his history, about the struggles that he has faced. And we're going to present you those reasons now why you should not impose a death sentence. Again, not an excuse for what he did. These are mitigating circumstances that you have sworn to give meaningful consideration to. And now's that time. So I'm going to give you a roadmap about some of this evidence that you're going to hear over the next couple of days. Each of you are going to listen to this yourself. You're going to hear the same evidence, you're going to hear the same arguments, and the same instructions from the court when we've completed our presentation to you. But again, you all have to come to your own individual conclusions on this. This is not, it's your own moral decision. It's a moral decision, not exactly like you did before. Now it's about you as a person, how you feel about these things. And we assume that you're going to trust each other and respect each other's decisions in this process. Because while you're all hearing the same information, in the end, you must make your own moral decision. So let's talk about some of the things you're going to hear over the next couple of days that you haven't heard so far. Stephen Wiggins' mother was severely beaten by his father while she was pregnant with Stephen. Stephen started getting beaten by his father before he ever came out of the womb. And he was born with a damaged brain. He has a hole in his brain. He has dead brain matter. And you're going to see and hear evidence of that during this trial. You will see the PET scans, the MRIs, and you're going to hear from experts who are going to talk about this. And I will remind you over and over again, we're not talking about excuses for behavior. We're talking about reasons, the circumstances of his life. So you take someone who's getting beaten before he's born with organic brain damage, and that's how he starts out life. Not surprisingly, he had seizures, continues to have seizures throughout his entire life, which evidences the damaged brain. Doesn't excuse his behavior for what he did in this case. We're past the excuses. This is not a justification. But it will help you determine what the appropriate punishment is here. Stephen's father, Stephen Wiggins' father, Scott Wiggins, he was mentally disturbed and medically untreated, which led to a violent and terrifying presence in Stephen's life for the majority of his childhood. He terrorized Stephen and the rest of the family while Stephen was growing up. He terrorized other members of the family before Stephen was even born. Those are some of the people you're going to hear from in this case. He was born into a violent, almost unspeakable environment with the organic brain damage on top of that. There was severe physical, sexual, and emotional abuse inflicted by Stephen's father. And again, not talking about excuses for behavior. These are things that you have to give meaningful consideration to in deciding what's appropriate here. A lot of people talk about, well, I had a tough childhood. You're not going to hear about a tough childhood. You're going to hear about a childhood where it was daily, physical, psychological abuse. Beatings for no reason. When Stephen and his brother couldn't fall asleep at night, his father's solution to that was to beat them until they went to sleep or just quit fighting. He would beat them with anything he could reach, fishing poles, his fists, his belt, daily. This wasn't once or twice. Stephen Wiggins saw his mother beaten when she would try to intervene. And this went on every day until he was about 14 years old, when Stephen's father chased him and his mother through the woods, shooting at them with a rifle, trying to kill them. And when they did finally get away, Stephen's father doused their mobile home with gasoline in an attempt to kill them. The environment Stephen grew up in was one where his father isolated the family like many abusers do. He didn't let them have friends. He didn't let them go places. He kept the door locked with multiple deadbolts and all of the windows covers because in his paranoia, he told the family, well, the police are going to come kill you at any minute. Ridiculous things like that were said to children, not once or twice, but every day for well over a decade. The brain damage that I've talked to you about when Stephen did this horrific act and he killed Sergeant Baker, that brain damage was untreated. But since he's been in custody and been observed for years now, he has been treated, and you'll hear about this, with powerful antipsychotic drugs and seizure medicine that has helped him to now be successful and manage his day-to-day life. Since he's been in jail and treated with these medications, he's not had any violent encounters with staff, who you'll hear from, or other inmates. You heard a little bit about the co-defendant in this case. She was not on trial here. But as a mitigating circumstances, you can consider that Erica Castro Miles shares some responsibility in what happened. Despite the environment he grew up in and the brain damage that you're going to hear about, he's not one-dimensional. It would be easy just to paint him with one brush and say, well, he's this act that happened in May of 2018. But he has, as you would hope, done some good in his life. He's done things, as I mentioned, like saving a coworker who had a heart attack. A fireman carries him out of a pit and gets him to the hospital and saves his life, and you'll hear from this man. Stephen had one respite in his childhood, and that was his mother's father, his maternal grandfather. That was the only place he could go and get a break. Unfortunately, that grandfather had a stroke around the age when Stephen was around 10 years of age. He ended up being in the house, hooked up on a number of machines, and then he passed away. Before he died, Stephen, as a child, learned to operate all of his equipment. As a child, he learned to clean out his tracheotomy so that his grandfather could breathe. He learned how to take his blood pressure. He did everything the nurse did except give him shots. And he did that when he was 10, 11, 12 years old. So he has done good things in his life, and you'll hear about those as well. Those don't excuse or justify what he did. It doesn't wipe away the terrible thing he did. But again, now we're talking about reasons that you would consider life. Stephen's mother, his aunt, his other family members, and most importantly, Stephen's son, Spencer, who's 10 years old, love him. And you will hear from some of those witnesses as well. Stephen has offered to plead guilty and receive a sentence of life without the possibility of parole. You will hear that. All the other factors you will hear as well in the next couple of days, such as his background, his life, his experiences, and anything else that arises from all of this evidence you're going to hear. It could encourage you, one or more of you, to extend mercy to him and vote for a sentence of life without the possibility of parole. Ever mindful that you're not looking for excuses or to justify what he did. We're past that now. And you've repeatedly promised us in the court that you would do just that. You would give meaningful consideration to this evidence, and I trust that you will. Because it's up to you to determine what's appropriate now. Whether he should spend the rest of his days in a concrete and steel box, around strangers, where he may one day die of natural causes, and whether that alone is sufficiently harsh, whether that's an appropriate sentence for him to die under those circumstances. And you'll hear the court's instructions at the end after we present all of our mitigation evidence. And only if all 12 of you decide unanimously that a death sentence is appropriate, then that's what will happen. But if you don't, then you'll be asked to consider life without parole or release. So what I'm asking you today is that you give this evidence the meaningful consideration that you all swore that you would do. You said in your questionnaires you could. You told us in Knoxville that you would. And now is the time to do it. After you've heard all of that, we'll be asking you to vote in favor of life without the possibility of parole for Stephen Wiggins. And I'm thanking you now in advance, for I know the time and attention that it's going to take. And I appreciate your giving this the meaningful consideration that you're required now to do.
Does the state wish to make any other statement?
No.
All right. Counsel, approach the bench, please. All right. Defense may call your first witness.
Your Honor, we've called Dr. Hamilton Small.
Step right up, doctor, if you will, please. Follow where the bailiff shows you, and we're going to ask you to raise your right hand and be placed under oath.
Do you solemnly swear affirm the testimony given in this case be the truth, the whole truth, and nothing but the truth, so help you God?
Morning, Dr. Small. How are you today?
Pretty good.
Would you please state your name for the benefit of the jury?
Arthur Hamilton Small.
All right. And
Can you spell your last name just so that our clerk, our court reporter makes sure that she gets it down?
Small.
It's just like it sounds. All right, thank you.
Dr. Small, what do you do for a living?
I'm a psychiatrist with the Middle Tennessee Mental Health Institute.
And how long have you been employed at MTMHI?
I've been employed there as a full-time psychiatrist since May of 2013, but I've been working there since 2004 as a what we call a medical officer of the day, where we admit people, where we evaluate people for admission to the state hospital.
I'm going to pass you, Dr. Small, I'm going to pass you a copy of your CV. And do you recognize that to be your curriculum vitae?
Yes, I do.
And let's talk a little bit about your educational history.
I attended the Medical College of Virginia for undergraduate, for my undergraduate degree, and also that's where I did my MD degree. I later went to, came here to Vanderbilt for my psychiatric training and residency, and that's where I graduated from.
Okay. And after you graduated, where did you first go to be employed?
After I graduated from Vanderbilt, I did a series of things. At that time, I opened my own practice. Subsequently, I worked at the VA, the Nashville VA, as a contract physician. And while working there, I would also go to the Murfreesboro VA also. During the same time, I would work, that's where I started working as the medical officer on duty for Middle Tennessee Mental Health Institute.
And what are your duties as the medical officer on duty at MTMHI?
As a medical officer on duty, we evaluate patients to determine whether they meet criteria for hospitalization. There are a few criteria that they have to display. One, they're either suicidal, homicidal, psychotic, or they're unable to take care of themselves.
Understood. Your Honor, at this time, I would move in Dr. Small's CV as the next numbered exhibit.
All right, Mark is the next exhibit, which would be exhibit
256.
256.
And I would ask that he tendered as an expert in psychiatric medicine.
State has no objection, then he will be tendered as a witness and qualified as an expert witness in the field of psychiatry.
Thank you, Your Honor. And were you on duty at MTMHI around June 4th, 2018?
Yeah.
And you were talking about earlier, when as part of what your job responsibilities are there is assessing, kind of triaging people that come in into MTMHI in distress. Is that a fair statement?
That is correct.
Right. And what are you looking for?
Like I said before, what we're looking for is for patients who meet criteria for hospitalization. One, they're either psychotic. Two, they're suicidal or homicidal. Three, they're unable to take care of themselves. Loosely interpreted, the patient is either an imminent danger to themselves or to others.
Okay. And I'm going to hand you records that you and I went over earlier. Do you recognize those records?
Yes, I do.
And what are those records?
This is what we call a certificate of need for to determine whether a patient meets criteria for hospitalization and for involuntary admission to the hospital.
All right. And how do you typically see those certificates of need?
They're usually done by doctors or members of the mental health community who evaluate the patient that presents to either the hospital or who's been evaluated by mobile crisis. Once those professionals make the decision that they believe the patient is suitable for hospitalization, they refer them to our hospital. And once they refer to our hospital, the psychiatrist takes a look at them, and the patient is, okay, then the patient comes to the hospital for a second certificate of need to determine involuntary hospitalization.
Okay. And this particular certificate of need, who was the referring physician?
The referring physician was Dr. Lindsay Evans Mitchell, the psychiatrist from the Davidson County Correctional Institute.
Okay. And who was the patient that she was referring?
The patient was Stephen J. Wiggins.
Right. And what's the date on the certificate of need?
The date on it is June the 4th, 2018.
Okay. And a little further down on the page under section C, there's some, what's the purpose of that subsection of the certificate of need?
This provides evidence to, for the basis of hospitalization. Question 1 usually talks about the patient's psychiatric condition, not condition, but whether they've had a psychiatric diagnosis before or they've been treated for a psychiatric problem before. Under question 2, what they look for is the immediate circumstances that the patient is presenting with. Question 3 talks about whether, treatment for the patient will help in alleviating the condition. And under question 4, what they look for is whether there's any less restrictive alternative that the patient has.
Okay. Now, let's go back to question 1.
Okay.
And you described kind of what question 1 was asking. Was there a response, a typed in response to or an answer to question 1?
Question 1 says, there's a reported history of behaviors clinically indicative of a psychiatric disorder. The second statement is, inmate stated, I'm hurting so bad, and tearful, rocking back and forth when asked if suicidal. And the third reason is, there's a history of a suicide attempt in January of 2018 and multiple prior attempts in the past.
Okay. And question number 2, and again, this question, as I understood it from you, is whether the person poses an immediate substantial likelihood of serious harm
Right,
due to the mental illness. Is that correct?
that's correct.
And what was the Dr. Mitchell's response, or excuse me, Dr. Evans Mitchell's response to that question?
It says deterioration due to mental illness to the point of inability to care for self at significant risk to health. Patient unable to contract for safety when asked about suicidal ideation, refused to comment, and says, in her opinion, the patient is at continued risk for self-harm if not placed under involuntary commitment.
And the response to number 3?
It says, treatment likely to prove beneficial in symptom reduction, high-profile criminal crime suspect with multiple risk factors for self-harm.
And if I understand you correctly, you can tell me, you rely upon this certificate of need when you're making your triage assessment.
It acts as a preliminary reference, really. Because what we do is we make our own decisions based on our evaluation of the patient. This is usually, and the first one is criteria that they would meet hospitalization, but for a patient to be hospitalized, they need a second certificate of need to be involuntarily committed to our hospital. At other hospitals, a lot of times they'll use this one, the patient will be able to sign involuntary.
But what you're reviewing here is to determine whether someone would be compelled to stay for psychiatric treatment, correct?
Yeah, if there's a second certificate of need signed.
So what do you do next? So you review this certificate of need to kind of give you the roadmap of what's happened up to the point where the patient sees you.
Once that comes in, what happens is the patient is next transported to the hospital. I should say in the past, before COVID, the patient will be transferred to the hospital for a face-to-face evaluation for inpatient to determine whether they meet inpatient criteria. Since COVID, they're not always transported to the hospital. Sometimes they're seen via telehealth, and at that time, you make a determination as to whether the patient meets criteria for hospitalization or not.
And if I understand correctly, it was your medical opinion that Mr. Wiggins on that date warranted involuntary committal.
Yes, I did. He had presented with suicidal thoughts. He had reported having some auditory hallucinations, and he had recently been arrested for alleged criminal activity.
And when you're doing this evaluation, are you observing Mr. Wiggins and talking to Mr. Wiggins?
Yes, we are.
Okay. And were you able to observe his demeanor?
Let me refer to that. On that day, we have what we call a mental status examination, and this is the results of the mental status examination. When we looked at his appearance, we said it was reported that he was in no acute distress, and he was somewhat disheveled. There was some psychomotor slowing. He was cooperative in behavior, and his mood was depressed. We looked at his affect. It was constricted and sad. His speech was low, barely audible. When we looked at his thought form, he had some slowness of thinking present, and in relation to his thought content, we saw he had some suicidal thoughts present. He wasn't delusional, but he was reporting visual and auditory hallucinations at that time. We went on to look at his orientation. We found that he wasn't oriented to time. When we checked his memory, immediately he was able to recall the items that we asked him. But when we tested it, after 5 minutes, he wasn't able to do that. To test his concentration, we did ask him to spell the word world backwards, and he got that wrong.
So you got it wrong?
Yeah, I mean, that's not unusual. That's not unusual. It's not unusual for some people to get it wrong. We looked also at his ability to reason, and we thought it was cognitively intact. They had asked him to explain some proverbs, and he was able to do that. When we looked at his insight, we felt it was fair because he had a general understanding of the symptoms and his need for treatment. All right. At that time, his impulse control was listed as good because he wasn't behaving impulsively towards us or anything like that. His reliability was fair in that he was able to provide some general history to us. We made a comment that the patient, his general affect is severely depressed, and he's endorsing psychotic features. There's no mania present. He has reported suicidal ideation without a plan, and at that time he denied homicidal ideation.
You said at one point, and if I understood you correctly, that he was not oriented to time?
Yeah,
What does that mean?
I mean, sometimes he might not know what the day is, or, what date it is.
Okay. And you talked about asking, at least you stated that you asked Mr. Wiggins a little bit about his history, and there's a medical history portion of this record, in your initial psychiatric evaluation report.
Okay.
And what medical history did Mr. Wiggins report?
He reported a history of seizures and epilepsy secondary to childhood trauma.
In any particular kind of trauma? When you say
Pardon?
childhood trauma?
Childhood head trauma.
Head trauma, okay.
Yeah. And at that time, he also had a rash on both of his arms.
About how long does this evaluation take for you?
I would say he was there for about 45 minutes to an hour or something like that.
Okay. And from your perspective, at some point, you're making the call whether or not he goes in for involuntary committal or he's sent back to wherever he came from, correct?
That's correct.
And if I understood you, your opinion was that he needed to be committed.
That's correct.
Was that based on the fear that he was suicidal, that he would harm himself?
I mean, he was meeting criteria for hospitalization, not only suicidal, he had endorsed some auditory hallucinations, and also what we know is he had a period of multiple prior suicide attempts. So given that history, we felt it was prudent to hospitalize him.
Now, in the records you have before you, I see a document here that says rationale for non-admission.
Right.
So if it was your medical opinion that he be committed on that date, why would there necessarily need to be a rationale for non-admission?
The reason that came about is after they had finished evaluating him, and had made the decision to hospitalize him, we learned from the transporting officers that they were not going to be able to release the patient into the custody of MTMHI, given, yeah.
And if specifically, I think this is your writing here, it says law enforcement refused to, and what's that word? Refused to,
I'm not sure which. I'm not sure which one.
and it's right under, in the rationale for non-admission, under your comments section.
Okay, to release custody of patient to hospital.
And based on that, it looks like you said the patient was returned to the jail?
Yes, Davidson County Jail.
Your Honor, I would move the record certificate of need into the next exhibit.
Any objection? All right, that will be marked as Exhibit 257.
Give me one moment. Is it fair to say that the involuntarily commit someone is a pretty serious step for a physician?
Usually with, yeah,
And so, I mean, you're not recommending involuntary committal for someone unless you have a genuine belief based on all of your expertise that they are a harm to themselves.
yes, sir, that's correct.
Thank you. Those are my questions, Your Honor.
Any cross? Thank you, doctor. You may step down and we'll release you from your subpoena. You may go about your business.
Thanks.
Defense may call your next witness.
May we approach, Your Honor?
You may. Okay. This is the Zoom witness, is that right? Oh, we have actually, this will be the Zoom witness. He has not, Mr. Evans, he has not yet.
Yes, Your Honor. Can we have a recess together?
All right. Is any objection to me advising the jury of factors? Ladies and gentlemen, the next witness that we're going to be presenting for the defense is going to testify via Zoom from our screen up there. So we need a moment to make sure that he's logged in correctly. And so if you'll step across to, we're going to allow our alternates to exit first so that we can keep them separated. And then we will allow the 12 who are our jury to leave the room. But we're going to take a short break to allow them to get this set up. So. This is Dr. Bigger, is that correct?
Yes, Your Honor.
For the record, we considered very first thing this morning the fact that the Mrs. Baker, when she gave her victim impact statement, testified under oath as a witness in this last witness for the state in the sentencing portion, and that inquired as on the record as to whether or not the defense wanted to ask any questions on cross-examination. It was affirmed that they chose not to after conferring with Mr. Wiggins. And we did that outside the presence of the jury, but it's my understanding that that was a decision that was made by counsel for both sides, that it was not necessary to address that issue in the presence of the jury, correct?
Yes, Your Honor, that's
All right,
correct.
let the record reflect both sides affirmed that that was a decision made out, that could be addressed outside the presence of the jury without having to have that done. So, and Any idea how long it's gonna take you to set this up?
Your Honor, I would hope within the next 5 to 10 minutes we can.
All right,
have it.
let's take about a 10-minute recess and give them an opportunity.
All rise. This court is in recess.